The second pillar of estate planning is the inheritance trust to keep your hard-earned assets in the family. Almost everyone's plan today has an inherent defect. There's actually no plan to keep it in the family. And here's why. Almost all estate plans today leave the assets, generally with a will, they leave the assets to their children. The parents do. They say generally in equal shares per stirpes. And what the per stirpes means is, if heaven forbid my son or daughter should die before me, their share to their children. Rarely, if ever, does a plan say, if my son or daughter dies before me, I leave it to my son-in-law or daughter-in-law. But what happens in the real world? In the real world, most children survive their parents, naturally. So let's say, for example, you had a son, and let's say you left your son $400,000. Unfortunately, a few years later, after you passed, the son dies. Who gets the $400,000 from him? Well, it goes to his wife, your daughter-in-law. Now, can she get remarried and share your $400,000 with a complete stranger? Well, she often will, because people live 31 years longer than they did a century ago. Now, this wasn't a problem until fairly recently. After all, did anyone leave you $400,000? Not too long ago, these inheritances were more like $3,000, $4,000, $5,000. But today, people are often leaving not $3,000, $4,000, $5,000, but often $300,000, $400,000, $500,000 and more per child, and are beginning to realize that there are ways to keep this inheritance in the blood. And the best way we know to do that is by setting up something called an inheritance trust for your children. And here's how they work. Let's call you the Smith family. And let's say you have 3 children. We'll call them Billy, Bobby, and Mary. When you come in today, we'll set up a Billy trust, a Bobby trust, a Mary trust. Now, there's nothing in them. They're empty. They're called standby trusts. They stand by till when? Till you're gone. Now, your plan says, when I die, instead of giving that $400,000 to Billy, I give it to the Billy trust. And say, Billy, I appoint you as the trustee. You're in charge. And he can do whatever he wants with the money. He can spend the whole thing. So you're not ruling from the grave. This is not a gift with strings attached. It's his money. He can do what he wishes. But the trust has 3 benefits, this inheritance trust. First, it says, Billy, if you happen to get divorced, what's the divorce rate these days? Maybe 50%? Spouse can't touch it. Separate property protected by the trust. It says something else. It says, Billy, if you get sued, well, who gets sued today in this country? Almost everybody. So creditors can't touch it, not in his name, not in his social security number. It's lawsuit proof. But the third thing, and the main reason people set up the inheritance trust, is that this trust says, Billy, when you die, presumably many decades later, whatever's in the Billy Smith trust, and of course it grew because investments grow, and he might buy real estate or mutual funds, but they stay in the trust, so they continue to grow, and the trust gets larger, and eventually one day when he passes, that trust says, Billy, the Smith money doesn't go to your spouse, that goes to your children. In other words, my grandchildren. Well, what if he doesn't have children? Then it goes to Bobby and Mary, the brother and sister. Then it goes to the nieces and nephews. So it always passes by blood instead of by marriage. Keeps your money in your family for generations to come. Does this sound like a good idea to you? Well, thousands of our clients have set it up this way, and it is the trend, certainly in estate planning for now and the future. Just a note here. Let's say you are particularly fond of your son-in-law or daughter-in-law, which of course many people are. What you might do, if you want to take care of them or provide for them, is you might say this. If Billy's wife, let's call her Debbie, if Billy's wife survives Billy and they're still married to each other at the time of his death, one of the things we can do is we can say, give half to my grandchildren at that time, keep the other half in trust for Debbie, give her the income only, and then on her death, that second half goes to the grandchildren. Now that money will still stay in the blood because it's still in the trust, so that if Debbie gets remarried, husband number 2 can't get it, and if Debbie ends up in a nursing home can't get it because of the trust. So you can actually pass it to the grandchildren in 2 installments, which has an advantage, of course, and take care of Debbie at the same time if you're so inclined. Just an option for you. That's the second pillar of estate planning.